2, 1. Okay. All right. Hello and welcome. Hello and welcome. Welcome to today's episode of the Empowered Immigrant Live. Thank you so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Today, our topic is love cases. Love cases in 2026. And so thank you so much for joining me here and welcome to today's episode of the Empowered Immigrant Live. All right. So remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. Today, our topic is love cases, marriage-based, love-based cases, and how those are being handled in 2026. And my question for you to consider is, hey, do you want to get a green card? Do you want to apply for asylum? Do you want to apply for U.S. citizenship? Do you want to discover whether or not you're eligible for a U visa or a T visa or VAWA or TPS or DACA or some kind of immigration option? Are you wondering what's the best solution to your immigration situation? Because if so, go for it. I'd love to help you with that in any way that I can. My firm is on a mission to win 10,000 cases in the next 10 years. We would love for your case to be one of them. All right. So thanks to everyone for being here and for tuning in. As always, as I am talking, if you have questions about your immigration situation, please feel free to submit them. You can do that by typing in the chat, or you can do that by asking to join me right here, right now, live on the internet. All right. And so that's that. So welcome. Thank you all so much for being here. Last time I shared a couple of pieces of bad news that I want to just give everybody a quick refresher on, and then we'll get into today's topic. Okay. So last Friday, February 6th, the Fifth Circuit, which is in Texas, it's actually Texas, Louisiana, and Mississippi, but the Fifth Circuit Court of Appeals in Texas published a case deciding that the government's position in matter of Yahure Hurtado, which I've done several episodes on, is, according to them, correct. All right. I believe it's incorrect, but according to them, that interpretation is correct, saying that undocumented immigrants are subject to quote unquote mandatory detention. And that case is the case of Buenrostro Mendez versus Bondi. And it has huge consequences, folks, has huge consequences. Because what that case means is if the government detains a person, say in California or in anywhere in the country, and then transfers that individual to the Fifth Circuit, Texas, Louisiana, or Mississippi, then once they're there, that circuit's law applies unless we file habeas first, right? That circuit's law will apply, which means that people in that circuit are going to be subject to mandatory detention, no bond hearings, no bond eligibility until you have completely fought your case. All right. And so that's big news. I needed to share that. Everybody needs to know that that is like really bad news, and that has happened. The other topic that I shared the other day is what's happening with the Board of Immigration Appeals. Okay. And feel free to go back and watch our episode on Tuesday. But the main thing that you got to know is if a case gets denied in immigration court after March 9th, according to this rule, after March 9th, you won't have 30 days anymore to appeal. You'll only have 10 days. All right. So you've got to be aware of that. And if you're coming up with an individual hearing after March 9th, then you really need to be talking with your attorney about what's your game plan if your case goes against you, if the judge decides against you. You got to be ready to appeal very quickly. There's other changes that are coming in this interim final rule that are making the appeal process almost a joke. All right. The BIA they're just going to summarily dismiss cases within 15 days. All right. And so we got to be ready. What that means is we got to be ready to file a petition for review to the circuit courts. And so that's where we're at. All right. Both of those are huge changes. And they are changes against us. All right. Just one thing after the next, after the next, after the next. It has been. So I wanted to share that. It's important for me to share that. And now I'm going to pivot. All right. I'm going to pivot and I'm going to talk about something that perhaps is happier news and is just better. And so I want to talk about love cases. All right. Maybe inspired by Valentine's Day, which is a couple of days from now. And maybe just because it's good to talk about these. But love matters, love cases. What are we talking about, right? How can we help our loved one? How can we help our fiance or our spouse, right? Adjust or fix their immigration status. And love is a wonderful thing. All right. I got married 17 years ago, and it's been the best thing that I've ever done. My wife and I are on a team, and we work together. We raise our kids as a team, and we figure out our business. She actually works inside my law firm as a team, and we hold each other accountable. Like, it just is great. I love being a husband. I love being a father. I love being in love. All right. I'm a romantic. You got to know that about me. If you don't know that about me, now you know. And I hope you can experience that. All right. And just so happens that my wife happens to be an immigrant to the United States. She immigrated as a young child to the U.S. And so, I want to share that some of the best immigration cases, especially right now, are love-based cases. All right, I'll repeat that. Some of the best immigration cases, especially right now, are love-based cases. All right. So what am I even talking about? Love-based cases. Really, what I'm sharing about is three things. First, I'm talking about fiancé visas. Okay. So if you're a U.S. citizen, you can petition to bring a boyfriend or girlfriend into the U.S. from overseas on a visa to allow the two of you to marry. And you got to get married within 90 days and then apply for your spouse's green card after the marriage. All right. That is a process, and it is still working. It is still approvable. All right. So if you are considering doing that, it is still possible. The second type of case I'm talking about is marriage-based adjustments of status. All right. And so if you're already married, so it's not a fiance anymore, you're already married, and if your spouse is already here, and if he or she is eligible to adjust status, then you can go through the process, and you have to prove the bona fides of your marriage. You have to prove that it's not just for immigration purposes. All right. You have to put work into it, and you then apply for your green card here in the US based on that marriage. That type of case is approvable right now. All right. And the third type of process is what we could call marriage-based consular processing. So this is if you're already married and if your spouse is overseas, right? Or if your spouse is in the US but not eligible to adjust, then in those situations, we can consider marriage-based consular processing. And so those are the three types of love cases, ways to adjust status or get a green card through marriage. And those are three cases that are still working with some caveats. All right. Each of these processes are long processes. Each of them are complicated. All right. Each of these have different eligibility criteria, right? They actually are covered by separate sections of law. They have separate regulations governing the way those processes works. And which process might be the right process or the best process for you depends on your specific situation. So we got to talk through all of that stuff from the outset, right? And we can do that, right? And you've heard of the different travel bans that are out there. There's the 40 country ban based on national security issues. There's the 75 country ban based on quote unquote the public charge doctrine. All right. So if you're from one of the 75 countries, but not one of the 40 countries, then the 75 country ban will bar marriage-based consular processing, but does not bar the fiancé visa process. Okay. And so that's important to be aware of. It's good to like think these things through. If you're thinking about getting married, or if you're thinking about starting one of these processes or another and you want advice about it, it's a good opportunity to get advice about it before, you want to get advice before the marriage if possible, and you want to get advice before applying for a visa if possible, so that you're doing the best process for your situation. All right. So that's really what I wanted to share today. I hope that's useful. I hope it's helpful. There are so many changes happening in immigration law. My my best advice is whichever process we're going through, we want to prepare it very well. We want to be very thorough. We want to be very professional. All right. We want to be ready to appeal if the government denies our petition or our request. We want to be able to, if possible, sue over it if the government denies it, because they are making rash decisions against us from time to time, more and more frequently. But I do want to share that these types of cases are approvable. They are winnable. Our office is continuing to process and win them. All right. The best advice, of course, is get good advice and don't go it alone. All right. Get support, get a team behind you, get empowered. Okay. So that's what I got for our episode today. Thank you very much. And so let me start answering whatever questions are out there. Okay. So Noel Diaz, I see you here. Thank you so much for being here. All right. You say, how is that fair if one half of the country can get bond and the other can't? Yeah. Well, it's not fair. All right, and thank you for saying this question. So let me just say, right, immigration laws are not fair. Like the idea of fairness is like just like throw it out the window. Like think about it. Think about it. The idea of the Immigration Nationality Act as it's been passed is that the law benefits certain people with certain types of documents and who were born in certain geographies, right? And that same law excludes or rejects or detains or deports certain other people with certain other types of documents who were born in certain other geographies. Like that's the discrimination, that's the divide, that's the unfairness that is built in fundamental to immigration law. All right. And it's like, you're right. It's not fair. All right. And so what are we going to do about it? Well, let's create a law firm and let's fight about it. Right. Like that's what we're here doing. And yeah, it is very much not fair. Okay. So Noel Diaz, I see your question here. Also, what kinds of cases do you think they will just dismiss? Yeah. Uh, appeals, first of all, it only applies to appeals that are filed on or after March 9th of 2026. So if you have an appeal that's filed and pending already, this does not affect you. Okay. But everything, what kinds of appeals are they going to dismiss? Every appeal. All right. The vast majority, it won't literally be everyone, but the vast majority of them are just going to be dismissed in 15 days. Okay. All right, let's see. FM0608. I see you here. Thank you for being here. You say, should I still apply for my wife's Colombian green card as a US citizen? Like, yes, you should. Yes, Colombia is on the 75 country travel ban. I get that. But you should definitely still submit your petition. You can go through the whole process. All right. You can go through the whole process, and it's just at that final interview that she won't be able to get a immigrant visa unless something changes about that travel ban. And now I should say that travel ban, there is a lawsuit that has just been filed. It was filed on February 2nd. I will be discussing it, all right, in my next episode of the Immigrant Litigator, which is our federal court review segment of our podcast. So if you want to check that out, stay tuned, subscribe to our channel, etc. You'll see when I talk about that lawsuit in more depth. But just be aware that there is a lawsuit that has been filed challenging the 75 country travel ban. All right. And so we're going to be following that closely, and I look forward to hopefully sharing something good that comes out of the federal courts challenging that particular ban. The other bans I think are going to be more difficult. Well, none of challenging these are not easy, regardless, right? But that's happening anyway. In my opinion, yes, you should still apply for your wife's green card. All right. AVM, is there a way to accelerate administrative processing in Ciudad Juarez? I wish. I wish there were. All right. I wish there were. Absent I mean, typically and generally speaking, no, there's not. All right. You can keep following up about it, though. You can keep sometimes the squeaky wheel gets the grease, right? And so, sometimes if you keep following up about it, you that can help to some degree. But 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 basically, no, right? There's no way to like expedite when a case is stuck in that administrative processing phase. All right, Ja Mikes, you say, so to get a married person in Jamaica right now wouldn't be affected by the travel ban. Let me just clarify that. Is I don't have my lists in front of me. 75 country travel ban. Okay, okay. It's taking me a minute. I'm sorry about this. Sorry about it. Okay, so I mean, sorry that it's taken me a little bit of time. It looks like Jamaica is on the list. All right. And so here's the thing. So you can get married. All right. You can file the petition. You can start the whole process. But if your spouse is in Jamaica and if they are going to their final interview, right? Which to be clear, if you start the process today, they wouldn't have a final interview for like a year and a half or 2 years, right? Typically speaking, because you got to go through the petition process, then the National Visa Center process, then the consular interview process. All right. And so at that final interview, if the travel ban is still in effect, then her case would be delayed, right? It would be put into administrative processing, and she would not be eligible for a green card to enter the US. If she's already in the US, she can apply for adjustment of status. That's different. But if she's out of the US, if she's in Jamaica, then no, she cannot get approved as long as this travel ban is still into effect. But if you're just thinking of getting married and starting the process, yes, you should do it, right? Get that process going, because 2 years from now, that travel ban should not be in effect anymore. All right. And, knock on wood, I can't predict the future, but, and we don't know exactly how long it is going to be in a place. And if we get active and vote to out the people that are currently in charge, then that will all change like on day one, right, of a new administration. So we gotta keep that in mind also. Politics can help change this also to some degree. All right, so Edit Ontuen, you say my VAWA was approved in 2023 and the AOS is still pending. Can you represent me to move my case forward? We'd love to. We'd love to, absolutely. Feel free to reach out, get in touch to schedule a consultation, and then we can discuss it, review your records, figure out what happened there, figure out if there's a reason that your case has been delayed, and we can go forward from there. Okay? AVM, oh yeah, you already asked that. Yeah, there's not a way to accelerate administrative processing in Ciudad Juarez. All right, Eddie Bemos, you say, are immigration law firms doing anything against this idea of stopping visa processing? Right, yeah. So there is a lawsuit that's been filed. It's been filed by several organizations in the Southern District of New York. All right, and so yeah, that is happening. That's going on. And so there you go. Stay tuned and you can learn more about it. As soon as I got more information about it, we can do that. Rosu, will the visa pause lift soon? My husband is in Australia and we are waiting for his interview. So Australia is not subject to is not one of the 75 countries that's been banned, to my knowledge at least. Let me verify that. Um, I should come into this with the full list. Um, but yeah, no, this confirms no, Australia is not one of the countries on the list. So you should get scheduled for your interview and good luck, and you can get a green card and get your immigrant visa in, right? So don't worry, your case is not subject to any visa pause. Okay. All right, it's just a slow process, because it's always a slow process. Um, Jessica, I see your question here. You say, I have VAWA prima facie eligibility. I have my EAD. I left my asylum for 8 years and they sent me to court. Got it. Got it. And so are you in court now? Like, do you have a hearing coming up? Because if you, okay, like you're going to need a lawyer, right? You're going to need a lawyer. And the good thing is you have VAWA, so you might be able to do what's called a motion to terminate your case in court, depending on your judge, or you might be able to file VAWA in court, right? And so, you can, if you don't have a lawyer, you need to get one. And my office is here to help. We'd love to help, right? We can help you with that, and we can certainly look at it and discuss your options and all that. Yeah. It sounds like you have options because you have VAWA, you have prima facie eligibility for VAWA already. So you have options in front of the immigration judge. You just need to, you know, follow the process correctly, and you should be okay. All right. So Edward Lopus, you say processes question mark. What processes should people just be able to do what they want? Yeah, thank you. Thank you for that. People should just be able to do what they want. 100%. People ought to be free, right? To live where they want to live and work where they want to work and live their life. What's the big deal? What is the big deal? And yeah, I mean, uh, I think that um, I think it should not be nearly as big of a deal as it has become. And we can agree or disagree about that, but that is my belief. And um, I uh, yeah, I really wish that we could change the minds and the hearts of certain political leaders so that they like actually understood that the people who have uh, come to the United States looking for a better life are here to contribute, and they're actually amazing. Like if you get to know people, people are amazing. And I wish that we could uh, just get more human beings who are in political leadership to be aware of that truth, because I don't think they're aware. A lot of people are just very, very ignorant about who immigrants to the United States are. And it's unfortunate. Like, I don't know how to change people's minds about that, um, but that's a tall order, but it is a task, something we all need to take on. All right. So I see a question here. How about visas? I have children who are U.S. citizens. Visa C1D, I think that says. So a C1 visa is for transit only. It's not a visa to even allow a person to stay in the US. And there are certain restrictions on the C1 visa. So if you have a child now who's a US citizen and wants to petition for you, I don't think we could review it. Feel free to contact our office and schedule a consult. But I don't think you're eligible to adjust status from a C1 visa through children, even if your child is turned 21. And so feel free to book a consult and we can look into all those regulations and the limitations and stuff with that visa category. We'd be happy to do that. But I do think that you are restricted. Okay. So anyway, don't take my word for it just right here, right now on the internet, because I'm not reading the code. But I do remember that there are, like, we've had this issue in multiple cases, and we've had to come up with different solutions. Okay. So let's see, Myra, you say nothing new with DACA. Correct. Correct. We're all waiting. We're all crossing our fingers. We're all like wondering when we're going to hear some big news about DACA. And we should hear some big news about DACA relatively soon. And we'll see. We'll see how long it takes. But yeah, we're talking Judge Hannon from the Federal District Court in Texas is reviewing a proposed settlement agreement regarding DACA and has been now for a few months. And so, yeah, it shouldn't be too much longer. Maybe the next 30 days, maybe the next 60 days, maybe the next 90 days. Impossible to know for sure, but they are working on it. Okay. All right, folks. All right. Well, I hope this was useful. I hope it was helpful. Thank you all so much for tuning in right now. I hope each of you has love in your life. I hope each of you has a wonderful Valentine's Day, uh, however romantic you are or aren't. And and yeah, I really appreciate each of you being here with me. If this was useful, if this was helpful, please feel free to subscribe to our channel. Please give us a like or a thumbs up or a heart. Please feel free to share it. Share our content with people who might be benefited from it. I really appreciate each of you. Oh, Lamarac, thank you here. So nice to hear that your wife's an immigrant also. Congrats on your 17 years of marriage. Hey, thank you. Thank you for being here. Appreciate that. Keisha, you say, I have a pending marriage-based green card. Is it okay to travel domestically to visit family? Yeah, yeah. If you have your receipt notices, especially if you have a work permit through your green card, you can use that typically to apply for a real ID driver's license, and then typically you're okay to travel domestically. You know, once you apply for a green card, once you apply for green card adjustment of status and you have those receipt notices, your status in the US at that point becomes a quote unquote adjustment applicant. Like that is your status in the US. So if anybody asks, hey, are you in status? Are you out of status? You say, yeah, my status is I am an adjustment applicant. And that doesn't necessarily mean that ICE can't, you know, they still have power for people in situations like that to some degree. But at least you can apply for a real ID driver's license. At least you can get a work permit. At least you've got some protections there. Okay. Let's see, Humberto. All right. You say 20 years in the USA after getting removed. How long will it take to come back? Man, thank you for being here and thank you for asking your question. If you had more than 1 year of unlawful presence in the US and then were removed, you have what's called a 10-year bar against you. And so there are ways to waive the 10-year bar. There are ways to waive the deportation order, but you can't even attempt to re-enter the US unlawfully, right? You've got to apply for those waivers from outside the US. I'd be happy to help you. Like if you're married to a US citizen, right? If you're eligible for a green card to come back, then hey, we can go through those waivers if you want to do that, and then hopefully get you a green card to come back legally into the US. Okay. All right, everybody. That's all I got for today. Thank you all so much for being here. I really appreciate each of you. My name's Otis Landerholm. I'm the founding attorney at Landerholm Immigration, APC, where we fight for your American dream. Thank you all so much, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot. Take care. Bye-bye.